Hello and welcome to the first episode of the Advocates Lounge. This is a series of podcasts being put together by Deer Street barristers. This is the first. My name is Dan Edwards. I'm a clinical negligence and personal injury barrister within Chambers, and this first talk will be on anticipatory costs. Orders for costs are ordinarily made at the conclusion of a discrete phase of the litigation, whether that is an interlocutory application, whether it's the resolution of a preliminary issue, perhaps the substantive litigation itself, or any appeal. In each of those instances, a judge will look back on that phase, they'll draw a line around that phase, they'll determine who the successful party was, and when it comes to costs, if they are not summarily assessed on the day, there'll be a detailed assessment with the receiving party entitled, of course, to an interim payment on account. But the court also has the power to make an award on account of costs, even when there's been no conclusion to any discrete phase. So in the traditional sense of the word, it's not entirely obvious who, if anyone, has been the successful party. It can make these orders when there is uncertainty as to the future progression or direction of the litigation, and it can make these sorts of orders when a detailed assessment is not on the horizon and may in fact be more than a decade away. And these forms of orders are called anticipatory, sometimes predictive or preemptive costs orders, and that's what I want to talk about today. Now, as you will anticipate, the power to make these orders flows from the discretion conferred by Section 51 of the 1981 Act. That gives a general discretion to the High Court and the County Court when it comes to costs. And those factors that a court is entitled to take into account are fleshed out in CPR 44.2. These sorts of cases are traditionally associated with heavyweight clinical negligence or personal injury litigation because those forms of litigation are both protracted and very expensive, and they really are the two drivers behind applications of this nature. So to take clinical negligence, if we have perhaps an injury sustained at birth through negligence, very often an asphyxial type injury, it can be 2 decades before the question of quantum can be addressed, let alone assessed with any sort of confidence. And within that time, of course, it's going to cost several hundreds of thousands of pounds to assemble the relevant evidence. Similarly, in personal injury, with, say, a traumatic brain injury, even with an adult claimant, it can still be a decade of treatment and rehabilitation before the parties can really get a grasp on the case management costs, the support worker costs, the care costs, the accommodation costs going forward. And that, of course, is where, in many cases, the real value lies. And this poses a real problem for those who are funding this litigation from the claimant's perspective. They're spending hundreds of thousands of pounds over a very long period of time with nothing coming back in return, which inevitably leads to cash flow problems which have been recognised by the courts. Now, these matters were thrown into stark highlight by 2 cases in 2019. The first was from the designated civil judge in Sheffield, His Honour Judge Robinson, and his decision was affirmed by Master Cook in the case of RXK. RXK was typical of the sort of case that will generate this type of an application. It was an asphyxial birth injury in 2013. The injury had profound consequences for the claimant. Liability was admitted by the trust in 2016, and the following year the court made an order that the claimant's entitled to judgment, and the claimant was given £100,000 on account of damages. And in 2017 the court also determined that the claimant was entitled to their costs on liability. Those costs were to be subject to a detailed assessment, and they were granted £50,000 by way of an interim payment on account of those costs. So far, so straightforward. But fast forward 2 years to 2019, and the claimant's solicitor returned to court before Master Cook with a cost bill saying our global costs now are nudging £500,000. We'd like another £150,000 by way of an interim payment on account of costs, please. But there was, of course, an issue because the costs order initially made was made in respect of liability costs. And those costs were essentially ended in 2017 when the claimant received judgment. What the claimant's solicitors in fact were seeking was an interim award against their quantum costs, and to date there had been no order for those costs. And Master Cook was dissatisfied with the manner in which this application was presented because it fell foul of CPR 42.2 subparagraph 8, which you'll see where the court orders a party to pay costs subject to a detailed assessment. It will order that party to pay a reasonable sum on account of costs unless there's a good reason not to do so. But there has to be an order that there is to be a detailed assessment. And as regards quantum costs, in this case, there had been no such order. So Master Cook made clear, as Judge Robinson had done previously, that the application has to seek costs down to a specific date, and there's no reason why that shouldn't be the date of the application itself. And the court can then order a detailed assessment up until that date on those costs, and an order can be made thereafter for a payment on account. In this case, Master Cook went on to highlight a number of additional issues which the court would require information on via the claimant's solicitor's statement before any award could be made. So Master Cook made clear that any application of this nature needs to be supported by evidence, and that evidence needs to cover the following. Firstly, the type of funding arrangement the claimant has, and any payments that have been made up until this date under that arrangement. Secondly, whether any Part 36 offers or any other admissible offers have been made. Thirdly, detail of any payments on account as regards damages that have been made to date. Fourthly, a realistic value of the claim, which is not easy in these sorts of cases, particularly at an early stage, but the court needs something to work with by way of a figure. Fifthly, there is an expectation that the claimant will present realistic estimates as to the quantum costs already incurred. Any other relevant factors which are listed here fall to be considered, in addition to the likely trial date, which is clearly critical. If it's in the next month or so, you're very unlikely to succeed in an application of this nature, whereas traditionally it will be years, if not decades away, which lends more force to the claimant's position. So all of this may seem very obvious to you, but spare a thought for the claimant's solicitors. In that case, it wasn't obvious to them. Master Cook described the claimant solicitor's application as little more than a cri de coeur. It seems we can't use Latin anymore, but French is okay. But Master Cook, in any event, sent them all away to start again and bring it back before him. But that at least gave him an opportunity to set out a blueprint for the rest of us, so claimants in the future don't make the same mistake. So you arrive back in front of your district judge or your master. What information do they need as regards the amount you're asking for? Well, again, Master Cook is on top of this. In a more recent case against Maidstone NHS Trust, he gave some general guidance as to what it is the court will be requiring when it comes to quantification. And he described these as the established principles. And in looking at those principles, he says the court is not here looking at an irreducible minimum. We're not expecting that every point will be taken successfully, but rather we are looking at a reasonable sum. He gave a rather lawyerly definition of what might be considered a reasonable sum, namely one that was an estimate of the likely level of recovery, subject to an appropriate margin to allow for error in the estimation. As I read it, that means if you say your costs are somewhere between £200,000 and £300,000, you can guarantee the court will be starting at 200 as a maximum. Thirdly, he talks about the relevant factors. These are not dissimilar to those we've already discussed. How strong is the claimant's case on costs? Is there any prospect of an appeal on any issues? What are the means of the parties? How far away is any detailed assessment likely to be? And whether the paying party will have any difficulty in recovering these costs in the case of overpayment. And this is an important issue because both His Honour Judge Robinson and Master Corp were in agreement that in the event of overpayment on costs, the defendant insurer can recover those costs from the claimant's damages. So there is clearly a tension here. The claimants will be making these applications, it might be said not unreasonably, to ease their inevitable cash flow difficulties over the years and decades these cases are running. But the defendant insurers will see things from a different perspective. They will be keen to engage with a claimant from an early stage to provide treatment and rehabilitation in the expectation that this will reduce their dependency in later life and presumably the overall value of the claim. But there is also a feeling amongst some insurers anyway that expeditious and proportionate litigation is not assisted by giving a claimant, as they would see it, an open checkbook throughout the currency of this litigation. That, they argue, encourages greater expense and delay rather than focusing everybody's minds. Defendants inevitably conclude that recovering damages and costs at the end of litigation focuses everybody's mind and encourages proportionate and reasonable conduct between the parties. So how can a defendant, if not protect themselves, at least ensure that these applications succeed only when appropriate? Well, the starting point, of course, is that these are liability admitted cases only. If liability is in dispute, it's very difficult to envisage how any such application would ever succeed. Secondly, Master Corp make clear that if things are working as they should, these applications should never come before the court. There should be an appreciation between the parties that claimants who are running protracted and expensive litigation with a judgment in their favour will be receiving voluntary payments on account of costs from the defendant. So any insurer who point blank refuses to engage in that way is unlikely to find any sympathy from the court when these applications are made. The converse, of course, if a defendant is acting reasonably, if a defendant is putting forward reasonable sums to the claimant on account of costs generally, that will give them significant leverage in the event that the claimant nonetheless decides to make an application for anticipatory costs. And the third limb is difficult, but perhaps the most powerful, namely the making of a Part 36 offer. No one underestimates the difficulty with valuing these sorts of claims at an early stage. That said, if a defendant makes a commercially appropriate offer early in the litigation, if it is a defensible Part 36 offer, the court is put in a very difficult position when an application for anticipatory costs is made. As we've discussed, the judge hearing that application will know about the offer. The sums in these sorts of cases are invariably large, and it will be for the claimant to persuade the court on the papers that that offer will be beaten. And that's no easy feat, given the paucity of evidence that the court is likely to be presented with at the time of the application. And additionally, operating on the court's mind, one has to assume is the fact that any overpayment will be recovered from the claimant's damages. And that is something one hopes neither party, let alone the court, ever wants to occur. Well, that's the end of my canter through anticipatory costs. I hope you enjoyed it. There will be many further episodes to come, so please stay tuned.